different circumstances that can result in removal orders from Canada. It is very important to know the steps to take when you receive a removal order from Canada. In most cases, the applicant will not be allowed to enter Canada and will be banned from entering Canada for 5 years. In this video, I will talk about the different types of removal orders, the steps to take in order to return to Canada, and information that you must know when receiving a removal order from Canada. There are 3 different types of removal orders. Specifically, they are a departure order, an exclusion order, or a deportation order. I will explain in detail each removal order and what is the specific requirements that are required from you. If you receive a departure order, you must leave Canada within 30 days of receiving the removal order. You are also required to inform Immigration Canada when you exit the country. Unlike a deportation order, you are not required to apply for an authorization to return to Canada, also known as an ARC. Moreover, you are able to re-enter Canada through any port of entry as long as you abide by the requirements of the order. Keep in mind, if you do attempt to re-enter Canada, an immigration officer can still refuse your entry because you were issued a removal order. However, if you fail to leave Canada within 30 days or fail to inform Immigration Canada of your exit of Canada, then the departure order will automatically become a deportation order. Therefore, at this point, if you would like to re-enter Canada, then you must apply for an authorization to return to Canada, also known as an ARC. In contrast, if you receive an exclusion order, then you must leave and stay out of Canada for a minimum of 12 months. Additionally, similarly to the departure order, you must inform Immigration Canada of when you leave the country. If you abide by these requirements, then thankfully you will not be required to apply for an authorization to return to Canada. Also, when you try to re-enter Canada, you can do so normally through any port of entry. However, the same circumstance applies. If you try to re-enter through a port of entry, the immigration officer has the authorization to deny your entry, only due to the fact that you have a removal order. On the other hand, if you decide to re-enter Canada before the minimum 12 months, or if you do not inform Immigration Canada of your departure, then you will have to apply for an authorization to return to Canada. It is important to note, if you were issued an exclusion order due to misrepresentation, unfortunately you will be banned from returning to Canada for a minimum of 5 years. Also, if Canada Border Services Agency has paid for your departure, then you will have to pay them back. Lastly, if you were issued a deportation order, then you must leave Canada and you will be banned from ever returning. The only exception to your re-entry to Canada would be applying through an authorization to return to Canada. That way, you may have a chance of being able to return to Canada. In many circumstances, people get confused with a deportation order and a direction to leave Canada. The two are very different, as a direction to leave Canada is not a removal order. Additionally, with the direction to leave Canada, you do not have to apply for an authorization to return to Canada and can return or re-enter Canada through any port of entry. Similar to the exclusion order, if TheVisa.ca has paid for your departure, then you must repay them. Consequently, if you have not abided by all of the requirements of your removal order, then you will have to apply for an authorization to return to Canada before re-entering Canada. It is always best to recognize the reasons for your removal prior to applying for an authorization to return to Canada. The reasoning behind this is because if the circumstances have not changed, then the likelihood of you being able to return to Canada are very slim. If you wish to re-enter Canada due to certain circumstances such as work, study, visiting, etc., then you must submit the appropriate application for those specific reasons. Therefore, your authorization to return to Canada will be considered with that application as well. To apply for an authorization to return to Canada, you must provide specific documentation such as a temporary resident visa form, a photocopy of your valid passport, 2 passport photos, a letter explaining why you should be permitted re-entry into Canada, and the processing fee must be paid. For applicants that have received a departure order or an exclusion order and do not comply with the requirements set out before them, they must actually have a letter of explanation explaining why they did not abide by the requirements. For any costs that are outstanding with the TheVisa.ca for your removal order, they will be informed to you while the application is being processed. It is extremely important for you to abide by the requirements of your removal order in order to gain re-entry into Canada. If you would like to apply for an authorization to return to Canada, we can definitely help you out with the process. Here at Akrami & Associates, we have dealt with many immigration matters and can definitely help you out. Conclusively, we have helped many of our clients with removal orders and applying for an authorization to return to Canada. If you need assistance, please do contact us. With Akrami & Associates, there's always a way.